New Jersey is seriously arguing that AR-15s are not in common use today? 2024? This isn't 1965 when these things were invented. The year before, in 1964, there's nearly 24 million of these in circulation. They might be the single most popular firearm by type in America today. But our good friends in the state of New Jersey believe that you do not have the right to them because they're not protected by the Second Amendment because they are not in common use. That and a heck of a lot more coming at you from this doozy of the case that, believe it or not, has already been accepted by the United States Supreme Court for review. Yeah, this is confusing. And get this, the judge in the ruling, a Bush appointee, a Bush Republican appointee, is going to piss everyone off by ruling both in favor of the Second Amendment and against the Second Amendment. Stick around to find out what happens here in New Jersey. Guys, let's get into it. So what the heck are we talking about? We're talking about the Assault Firearms Law of 1990. Not my name, New Jersey's name. And who do we have to thank for this? Well, today's video comes to us thanks to our good friends at the Firearms Policy Coalition FPC, who cranked up their famous lawsuit printer, and thanks to them, we are back here at it once more. They've had a lot of fantastic victories recently. In fact, they have more victories than I can cover. I'm going to be trying to get into them, but be sure to check them out. They deserve your support. They, along with many other groups, GOA, SAF, National Association for Gun Rights, be sure to check them out. Support, join as many as you can. Go ahead, check them out. Also joined by the Association of New Jersey Rifle and Pistol Clubs Incorporated. Those two are part of the same lawsuit, aggregated together. There's basically two different things that we're talking about here. I'm going to cover them in turn. The first one, we're going to be talking about so-called assault weapons, i.e. modern sporting rifles, before we turn to so-called large capacity magazines, LCMs, in other words, just normal capacity magazines. I've got a lot to say on both, but first we're going to start with a temper tantrum from the court. I'm going to read this to you. If you ever wondered, do judges have temper tantrums? The answer is absolutely yes. Here's what it says from the decision, quote, "It is hard to accept the Supreme Court's pronouncements that certain firearm policy choices are off the table when frequently radical individuals possess and use these same firearms for evil purposes." The court then goes on to observe the fact that, hey, I'm stuck following what higher courts say, which, by the way, includes the U.S. Supreme Court. P.S. Someone get this memo over to the Hawaii Supreme Court. Just quick heads up there. The court goes on to say, quote, "This principle, combined with the reckless inaction of our governmental leaders to address the mass shooting tragedy afflicting our nation, necessitates the court's decision. For those reasons and those below, the AR-15 provision, spoiler alert, of the assault firearms law is unconstitutional, and, spoiler alert, the large capacity magazine amendment is constitutional." Half right? What road did he take to get there? And keep in mind, this is a Bush-appointed Republican judge, albeit in New Jersey, they do things a little differently out there. Starting with AR-15s. We've got a lot to get through. I'm going to get through this as quickly as I can because there's a lot of shoveling that you need here, so I hope you brought your shovel with you today. So first, New Jersey is arguing, the government is arguing that AR-15s are not protected by the Second Amendment. Quote, specifically, state defendants argue that AR-15s are not in common use today for self-defense and are therefore not covered by the Second Amendment, end quote. All right, so for those of you who are old enough to be like me, two things. One, you probably had some ibuprofen in the morning. Go get him, Tiger. Number two is the fact that you probably remember a time when the anti-gunners were always saying something like, hey, you can't use that for sporting purposes. You can't use that AR-15 for sporting purposes. You can't use that Glock for sporting purposes. They invented this sporting purpose test as if the Second Amendment was made for some sort of sporting purpose like shooting trap or skeet or hunting or something like that, right? That was what we had to suffer through for the better part of the last 20 to 30 years, frankly, up until, thankfully, the U.S. Supreme Court kind of kicked into gear. Well, here we have them moving the goalposts again, except this time they are stuck and they've had to resign and abandon that initial set of trench work, which revolved around this whole inane notion of sporting purpose tests. And now they have a self-defense purpose test, which may not seem too bad until you see how they want to do that test. So here the court correctly teases apart what they're trying to do. They being the anti-gunners, they being the government. In this case, we're talking about New Jersey. What the court observes is that they're trying to set up a four-way test to determine in common use. One, it has to be in common use. Two, it has to have a lawful purpose. Three, evidence of the total number of self-defense incidents involving the relevant firearm in question. Okay, so obviously 1 and 2 has to be legal, fine, whatever. Has to be legal for a particular purpose, fine, whatever. That's part and parcel with, is it in common use, I suppose. Otherwise, I suppose you need number 2 to rule out Glock switches or something like that. But when we're talking about evidence for total number, okay, so now we've just tried to insert into the Constitution, insert into the Second Amendment that, hey, you can only have firearms if there's a statistically quantifiable data set to show that that particular firearm has been used in enough firearm self-defense cases, and we'll be the ones to decide if that's enough. Do you remember that in the Second Amendment? I'll be honest, I don't remember reading that in the Second Amendment at all, anywhere. And then number 4, the court goes in to say that this analysis would also consider, number 4, the characteristics of the firearm itself and the usefulness for self-defense. In other words, even if you had a lot of firearms that are being used in self-defense successfully, if the characteristics of that firearm are somehow not exactly in keeping with that purpose as determined by the experts that you and I don't get to choose, the government and the anti-gunners will choose those experts. They will choose how many self-defense incidents is relevant enough. Once you meet those 4 criteria that they and only they get to decide and, of course, move the goalposts on, then it will be good enough. How many of you in the comment section actually believe that if we allowed that to happen, 20 years from now, we would have anything resembling a right to bear arms, a right to self-defense, a right to carry firearms for self-defense? Is there anyone out there who actually thinks that that would work? Let me know in the comment section. Thanks for checking out this video. Be sure to hit that like button. My question for you in the comment field down below is, where do you think this is going? It's already been to the U.S. Supreme Court once. Now it gets back there again. Is it going there? Do you think it's going to get there? And which one do you think is more crazy? The government's arguments, the anti-gunner arguments for AR-15s or for magazines? Let me know in the comment field down below. Now back to the video. Now the FPC, in contrast to this government anti-gunner 4-way test, basically has this to say, because remember, this all goes back to what Heller had on page 627. I'm not making this up, 627 in Heller, where the Supreme Court wrote, quote, "The sorts of weapons protected were those in common use at the time," end quote. FPC has the audacity to ask, are they in common use at that time? No 4-way test, just there it is. And the judge is basically kind of stuck going along with this. And the judge is forced to write, for your amusement and mine, as of 2022, it was estimated that there were around 24 million AR-15s and similar sports weapons in circulation. Similar sports weapons, man. I mean, that must be the Texas appointed coming out from the Bush appointee aspect of the judge. But don't worry, we're going to get to the New Jersey, gone native elements, unfortunately, soon enough. Now, just to wrap this up, and this is going to be, I think, a growing trend. Look for this as we see courts move along. The court also pointed out that, look, the plaintiffs have further shown that AR-15s are well adapted for self-defense. There has been evidence and experts that have testified as part of discovery here, building on the fact that AR-15s are well suited for self-defense because they're lightweight, they have mild recoil, they have good ergonomics. I'm not saying this. This is what the court said. And it's a weapon that's well suited to younger shooters, female shooters, and other shooters of smaller stature. Again, not what I said, what the court said. I will also add, the court said this in a slightly different way, but I'll encapsulate it like this for you. The caliber is also effective in self-defense, per the court. By the way, if you don't like anything I just said, keep this in mind. If you don't like anything I just said, you're probably one of those people who think that the AR-15 is so incredibly deadly that it should be banned. If it's so incredibly deadly on offense, then how come it cannot be good on defense? Right? You can't have it both ways. It cannot be such a horrible weapon of mass tragedy and then yet so uniquely ineffective and unsuitable to self-defense on the other hand. Right? You got to pick a lane here. You can't have it both ways. So the court, like Nancy Reagan, just said no. All right, the dominoes in this are going to fall quickly. Stay with me. The first big question that anti-gunners say is, look, detachable magazines, they're not an arm. They're not protected by the Second Amendment. And the court basically says no. And they say no, citing back to the United States versus Miller Supreme Court decision from 1939, which said in part, quote, the possession of arms also implies the possession of ammunition, end quote. And of course, by the transitive property of 8th grade math, if we need ammunition, then we need magazines, and you can kind of start to get there, all right? Also, as a note, the Third Circuit Court of Appeals, which is where we are, already ruled that magazines feed ammunition into certain guns, and ammunition is necessary for such a gun to function as intended, and basically, therefore, magazines are arms within the meaning of the Second Amendment. Fine. New Jersey has backups. New Jersey next argues that large capacity magazines are not in common use today for self-defense and are therefore unprotected by the Second Amendment. New Jersey basically once more comes up with this whole self-defense test and says, look, most civilian self-defense shoots involve less than 10 shots. Ergo, these aren't for self-defense and they're not commonly used in self-defense, so it's not protected under the Second Amendment. The court basically says, yeah, we kind of already dealt with this sort of reasoning up above. I'm just going to add this for you, dear viewer, that NSSF already came up with their own study showing approximately, and I have to urge, this is an extremely conservative number, how many magazines, what percentage of those would qualify as being large capacity, i.e. more than 10 rounds. So of the estimated 963 million detachable magazines supplied by fire manufacturers as well as in the aftermarket, at least over 717 million have a capacity exceeding 10 rounds. Now, I did the math for you. 73% rounding down are therefore large capacity magazines. 73%. That's about 3-to-1 of the magazines are large capacity versus not large capacity, which would seemingly make the large capacity magazines the normal capacity magazines and the non-large capacity magazines the small capacity magazines. Well, here's where the New Jersey kicks in. Next, what the court says is this: since these normal capacity magazines did not exist in any meaningful commercial way in the civilian marketplace until about the year 1900, maybe even the 1920s or so, the court uses a slightly different test than just the straight history and tradition under Bruin test. Let me know in the comment field below if you want me to blow this up and to go into more detail, because they're not wrong that it's a slightly different test if we're faced with new technological innovations. Basically, what the court does in a misapplication of that test is they say, look, how does the normal capacity magazine law and how does the burden banning these normal capacity magazines, how does that affect and burden the Second Amendment rights? And have similar burdens been okay historically? Again, very low resolution here. The court basically ticks off a bunch of mass shooting statistics, and as soon as you see courts go into that, you know what they're going to do. But they start going through mass shootings and all this other kind of stuff before bringing us back to, yeah, you guessed it, Bowie knives, 1830s Bowie knife regulation, because obviously that's where this all comes around. The fact that New Jersey was really going for, hey, look at all this Bowie knife regulation, the 1830s and 1840s, because it was so incredibly dangerous back then. You know, back before the Second Amendment applied against the states, back before the 14th Amendment was ratified, back before Chicago versus McDonald in 2010, which meant that back then the states could ban whatever they wanted because there was no Second Amendment. The Second Amendment, though passed in 1791, did not apply against the states. But at any rate, though, the judge basically says, yeah, on the one hand, normal capacity magazines dangerous. On the other hand, Bowie laws from the 1830s, good enough. If you want to read the case, it's of course linked in the description box below. Again, that's the very broad strokes. Now, if you're in New Jersey, first off, I'm so sorry. Catch an Uber, get out. Why have you not done this already? But just be warned, look, yeah, they struck down this AR-15 part, which is very awkwardly worded because it actually did away, if you read the order, with Colt AR-15s, but if you read how the statute's set up, basically it does away with all the AR-15 ban. But the court, knowing that probably both sides will appeal it, which they have, put a 30-day stay on it. So long story short, this is all an academic exercise. We're going back to the Third Circuit Court of Appeals, and likely, if this has not already been settled by the United States Supreme Court, it may get aggregated into another case, because again, this has already been accepted. Writ of certiorari was granted back in June of 2022, and I suspect that with this already thoroughly on the Supreme Court radar, it may be getting back on the docket in one way, shape, or form or the other. We'll be following this one. Let me know in the description box below. What do you think about all this? What did you think was the most inane argument that our good friends in New Jersey had? And our good friends in New Jersey, why? Why are you in New Jersey? Like, west. Go where the sun sets. Just drive in that direction. Go. Thanks for sticking around this long. Don't forget to hit that like button if you've not already done so. Join the discussion in the comment field down below. And our quote of the day comes from noted Roman thinker Seneca, who once said, "We suffer more in imagination than in reality." Unless you're from New Jersey, then you may have a defense to that. I look forward to seeing you in the next video. You take care. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.